And welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know using that same questions tool, and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of that recording with you via email in the coming days. So without further ado, I would like to hand over to our speakers to get us started.
Thank you very much, Lucy. My name is Christopher Ricciuti. I am a partner at the Oblon firm in Alexandria, Virginia. We are a full-service IP boutique focusing on everything from patent prosecution to litigating throughout the federal courts in the United States, to litigating before the Patent Trial and Appeal Board, which we'll be talking about today, copyright, trademark, opinion work and due diligence, you name it. If it's related to IP, we do it. I've been at the firm for a little over 11 years. My background is in mechanical engineering, but I litigate all sorts of technologies ranging from high-tech and computer technologies to medical devices, even to pharma cases. And I couple my district court and federal circuit litigation practice with a substantial workload before the patent trial and appeal board and really post-grant proceedings at the USPTO. With me is my colleague, Alec Royka. He's an associate in our litigation group here at Oblon, and I'll let Alec tell you a little bit about himself.
Thanks, Chris, and hi, everyone. My name is Alec Royka. I'm a associate at Oblon, joined the firm in 2020. And similar to Chris, my practice mainly focuses within the litigation and post-grant practice group here at Oblon. I do handle a little bit of prosecution work as well. My background is primarily in civil and environmental engineering, but as are most people at Oblon, my practice tends to range between high-tech, pharma, medical devices, any kind of technology that comes in the door.
Thank you, Alec. And so with that, I just want to give everyone a very brief overview of what we'll be talking about today. I like to begin any PTAB talk with some recent IPR statistics. I find that they're interesting and not only interesting, but I think fairly informative about practice before the board. Alec will then talk to you about the Apple v. Fintiv discretionary denial practice that used to be occurring at the USPTO and kind of how that has changed under Director Vidal. Alec will then turn it back over to me. I will explain at a high level the director review process for those that may not be familiar with it yet, highlight some exemplary decisions that we've seen out of that director review process, and then Alec will conclude the main substantive portion of this, either morning or afternoon or evening, depending on where you are, with some recent guidance that's come out of the USPTO under Director Vidal. Then, of course, we'll give you some concluding thoughts and thoughts about the future. So on the slide here, I just have overall filings from the 2021 fiscal year, and this data is produced from the USPTO itself. You can see that IPRs and post-grant proceedings are still very popular. There have been a total of 1,367 post-grant proceedings in the 2021 USPTO fiscal year, which isn't the traditional yearly fiscal year, but the vast majority of that, as you can see, 97% are IPRs. A little over 1,300 and a few dozen post-grant reviews are filed each year. That has been the historical trend. For those who are curious about the difference between the IPR and the PGR practice, post-grant reviews are only available for first inventor to file, or AIA patents, and they have to be filed within 9 months after the patent issues. And they are a very broad tool where parties can challenge both unpatentability grounds, but then also written description, enablement, unpatentable subject matter under 101. And because of that, if you file a PGR and it's unsuccessful, the scope of how you may be able to challenge that patent in the future is very limited. And I think as a result of that, coupled with the fact that not all patents are available for PGR, we really do not see many PGRs filed year after year. It's, again, a very small percentage of a much larger bucket of post-grant work that's occurring at the USPTO. Looking on the right, there's different technology types where people are filing these proceedings, and probably nothing surprising there. The vast majority of it is in the electrical and computer space, coupled with business methods and mechanical inventions, and maybe 15% or so representing the unpredictable arts, your biopharma and your chemical cases. The institution rates are shown here on the next slide, and this is historical from 2017 to 2022. And the way I always think about it is the institution rates always hover around 60%. It might be at 60%, it might be a little bit higher, it might be a little bit lower. Alec will talk about this in a few minutes. We can see when the FINTIV discretionary denial practice was very prevalent before the USPTO, that the numbers actually dipped below 60% and somewhat substantially below 60%. I don't want to preview the conversation too much, but FINTIV is slowing, and we will hit that later on. And as a result, we are seeing an uptick in institution rates by petition. It was at 67% for fiscal year 2022. By patent, it was at 70% institution rate. And that number is a bit of a historical high outside of the very first few years of IPR practice. The reason that we show here on this slide, and also the Patent Office shows institution rates by petition and also by patent, is because it's possible to file multiple IPR petitions against any given patent. And because of that, we'll typically see the institution rate per patent be a few percentage points higher than what we see the institution rate by petition. If we look at institution rates by technology, again, nothing all that surprising here. Especially when we look at the big ticket players, so your electrical computer, your mechanical and business method patents, those institution rate tend to stay right around the overall institution rate for IPRs and for post-grant proceedings. Biopharma and chemical, actually biopharma tends to be fairly high every year. Chemical, as an unpredictable art, as you would expect, tends to be one of the lowest institution rates. And with design patents, you really can't draw any data on design patent institution rates and numbers because the numbers filed every year are so low. You can see here in fiscal year 2022, there were only 3, and there was a 33% institution rate. I recall going back a few years prior, the design patent rate might have been 4 out of 5 or 80%. So the numbers are just too low to kind of take any sort of guidance at the percentages when it comes to design patents. So here is a chart that the Patent Office puts out every year on case outcomes. And again, this is for fiscal year 2022. And so they look at claims and patents, claims that were challenged, and then they distill it down to, well, what happens, or they try to distill it down to what happens at final written decision, or just overall in these proceedings about how effective they are as a tool to render a claim unpatentable. And they state that there's 26% of challenged claims and 53% of instituted claims were found unpatentable by a preponderance of the evidence. And that is true overall and versus the overall magnitude, but that number isn't all that instructive, I don't think, for parties who find themselves before the PTAB, whether you're a petitioner or whether you're a patent owner. So on a case-by-case basis, if an IPR is filed against your patent, for example, and it does proceed to a final written decision, what's the likelihood that claims are going to potentially be found unpatentable? This is the statistic, or the chart that the Patent Office had put out this year in fiscal year 2022. And they note that 12% of patents with proceedings ending in fiscal year 2022 were fully invalidated, and then a very, very small percentage of all live patents in fiscal year 2022 were fully invalidated. So you're really not able to actually necessarily see the rates on the basis of a final written decision, because the numbers of final written decisions aren't necessarily posted in here or aren't easily discernible. So I will switch now to the next slide, which is from last year, fiscal year 2021. And here that you can see there were 340 patents that received a final written decision, 265 patents lost one or more claims, and 73 patents lost all their claims if they proceeded to final written decision, which translates into an approximate 78% chance in fiscal year 2021 that if you proceeded to a final written decision, at least one of your claims, if you're a patent owner, would be invalidated. The number was actually at 84% in fiscal year 2020. And when you look at the historical trends, it always tends to hover around that 80% mark. And so what's the takeaway here, at least from my perspective, is that there's two numbers to remember that help you kind of ballpark the institution rates and I guess lethality of IPRs. It's generally somewhere in the 60% range that any given IPR petition will be instituted. And then if you're instituted and you don't settle and you proceed to a final written decision, there's about an 80% chance year over year that at least one of your claims is going to go away. So as a patent owner, your best chance of avoiding some sort of unpatentability finding is either not have your patents show up in IPR at all, or if there is a petition, to do your best in the pre-institution proceedings to not have that case go forward. And with that, I will turn it over to Alex so he can give you a historical perspective on FinTIV and what's happening with FinTIV currently.
Thanks, Chris. And I think this kind of transitions nicely over from your initial point on as a patent owner, your best chance is likely avoiding institution altogether. And when anyone was talking about the Patent Office within the most recent 2 years, you'd be hard pressed to find any conversation that didn't focus around FinTIV or didn't at least touch upon FinTIV. This was the big topic within all Patent Office kind of circles within the past 2 years. But what is FinTIV? And so this was a 2020 decision from the board looking at discretionary denials under Section 314A. And the panel here came up with a series of 6 factors to evaluate whether or not the Patent Office should institute an IPR or a post-grant proceeding here, depending on a concurrent district court or ITC litigation. And so really what the court was focusing on, or what the PTAB was focusing on here, was conserving PTAB resources. The Patent Office was primarily concerned with not instituting an IPR if there was already a district court litigation. Then the district court would potentially reach a final judgment prior to the final written decision in the IPR. And so primarily this second factor was really the big one for parties that a lot of petitioners were upset about and that patent owners kind of liked, was the proximity to a court's trial date to the board's projected statutory deadline for final written decision. And so this would vary greatly based on whatever venue outside of the patent office that the parties were involved in. For example, the Western District of Texas has a much faster time to trial and sets a much more aggressive trial schedule than, say, a district court within the District of Wisconsin. And so here it is essentially what petitioners were concerned about here was that this essentially added another barrier towards institution that was not in the original statute that Congress had enacted when they had created these IPR proceedings.
And Alec, actually I have a question here about, how did FinTIV become something, a practice that the board followed? Was this, some sort of statutory rule? Did it come out of some sort of precedential opinion panel or precedential decision from the board?
Yeah, so that's a great question. This was initially just a decision based on from a regular PTAB panel, nothing special about it. It was only after this decision was enacted that Director Iancu at the time designated this opinion as precedential, meaning that the analysis and the ultimate holding here was something that Director Iancu wanted applied consistently throughout the patent office, and essentially by designating it precedential, ensured that future panels at the PTAB would be following this same guidance.
Got it. Thank you. And let me know when you're ready to go to the next slide.
Yeah, I think we can move on.
All right.
Yeah, and so just here, we have a couple different graphics up showing discretionary denials historically, and primarily what we are interested here is this 2019 to 2021 range. Obviously FinTIV was had come out in 2020, but the predecessor to FinTIV, NHK Springs, was released in 2019. And so as you can see from this first graphic on the left, procedural denials began increasing in 2019, and then in 2020 we saw an even greater number of procedural denials, and that was likely due to FinTIV. What you see here in 2021 on this chart on the left, it's a little bit misleading, as you can see right below that data is only through September 30th for 2021. So we are missing the final 3 months of the year there for this data. But based on everything that we can tell is that 2021 as a whole would look very similar to what 2020 looked as a whole when all the numbers do finally come in. And so you're going to see a greater number of procedural denials for institution. You see a lower number of actually instituted petitions, and you see just less of a denial related to merit-based denials. And then taking a brief look at the chart on the right, you see what those procedural denials are, how they actually shook out. And what we're focusing on here is the 314A discretionary denials. This is the FinTIV denials. And so you see that really starts to expand in 2019, reaches really that critical mass or that peak in 2020. And then again, numbers in 2021 will, if all 12 months are included there, would look very similar to what we saw in 2020. And so you're just seeing a much greater number of denials based on FinTIV, meaning that the panel is not really considering the ultimate merits underlying these IPR petitions, is denying these petitions based on time to trial and concurrent proceedings. And so the big change then from 2021 into 2022 is obviously we have a new administration at the USPTO. Director Vidal was confirmed in April of 2022, took office and pretty much hit the ground running here. And so almost immediately in June, Director Vidal issued some guidance more or less reining in FinTIV. While FinTIV still is on the books, this guidance is more or less now is what is governing discretionary denials under 314A. And so petitions will not be denied under FinTIV if they present a compelling evidence of unpatentability. Petitions will not be denied based on parallel ITC proceedings, and substantial weight will be given to certain stipulations that petitioners may file with respect to the prior art that is asserted within the petitions. We'll talk a little bit more about those in a later slide, but there are more or less three different petitions that, or three different stipulations that petitioners may file. And based on those three different, based on what stipulation is filed, they are kind of given a little bit different weight. And also importantly is this final point here is that the PTAB, when deciding whether or not to deny institution based on discretionary grounds, no longer looks at the actual case schedule in the concurrent proceeding, but is now actually looking at the median time to trial in a given district. And so this is potentially in reaction to some of the more aggressive schedules that can be set in district courts in the Eastern District of Texas as well as the Western District of Texas, now giving petitioners a little bit more leeway and leniency for when they are filing their petitions. And
actually, we have another question here, Alec, on I guess the first bullet point on your slide. The audience member wants to know, how is number one, so I guess a compelling evidence of unpatentability, how is that different from the typical standard to get an IPR or a PGR instituted?
Yeah, that's a great question. So obviously we are dealing with the compelling evidence of unpatentability, and for institution, the institution standard is a reasonable likelihood. And so when we're dealing with any of these kind of standards of review or or burdens, they are a bit amorphous, but I think clearly based on the language here, compelling evidence of unpatentability is a higher ground, is a higher threshold than the reasonable likelihood of success. How much more? That's not entirely sure. Potentially, if we think of reasonable likelihood as being more than 50%, compelling might be 66 or 75%. But I think Director Vidal has also addressed this a little bit in that has kind of classified compelling evidence of unpatentability as if unrebutted, the evidence would plainly or clearly lead to unpatentability in this instance. And so I think we're going to get a clearer picture as more PTAB institution decisions citing to this guidance are released. And we also have some more director review decisions citing to this guidance. But as of now, I think what we have is Director Vidal's comments. We know that compelling evidence of unpatentability is a higher institution threshold than reasonable likelihood, and that focusing on if unrebutted, it would clearly or plainly show unpatentability. I think we can move on. And so since this guidance, what has happened to FinTIV? What has happened to FinTIV in 2022 since Director Vidal took office? And as you can see from the graphic on the left, you have FinTIV, NHK Spring FinTIV discretionary denials in 2020 and 2021 up in the upper mid 80s there. And then moving on to 2022, you have only 13 FinTIV discretionary denials in 2022 so far. And that is not spread out throughout all of 2022 either. If we kind of take a look over to the graphic on the right, we see this based on, we see these denials on a quarter by quarter basis. And as I had stated previously, Director Vidal did not come into office until April 2022, and this guidance was then issued in June of 2022. So quarters 1 and quarter 2, you see the majority of the discretionary denials under 314A, and then moving on to then quarter 3, after this guidance had been issued by Director Vidal, we have only 1 discretionary denial. And this is actually even a kind of a unique circumstance, and Chris will focus on this a little bit later with that specific case, but that is actually currently under review by the director herself. And so some final takeaways on FinTIV. We're going to take a look from the petitioner side as well as the patent owner side. But looking first from the petitioner side, based on the numbers and the statistics that we just saw, it does appear that FinTIV practice is effectively over. Since Director Vidal issued her guidance in June 2022, we only have 1 discretionary denial on the book so far, and that is a bit of a unique circumstance anyway. So I think petitioners should feel fairly comfortable that FinTIV is not going to act as a major hurdle for them. And obviously we see, based on Director Vidal coming in versus the previous administration at the PTO, these discretionary denials are very influenced by the director. The director has a lot of control over how he or she wants to view these IPR petitions and the best use of PTAB resources here. And obviously, FinTIV is still on the books. It has not officially been overruled by the PTAB or the Presidential Opinion Panel. And so stipulations for petitioners that are filing with concurrent litigation at this point can still be a very effective tool and something that petitioners should likely be discussing. And as I had mentioned previously, there are 3 different styles of these stipulations. At the strongest end, you have the Cetera style stipulation. This was really the original stipulation, and this is essentially a petitioner stating that if institution is granted, then they will not raise any invalidity grounds that were raised or reasonably could have been raised in the IPR petition. And so this essentially forecloses that petitioner from asserting any patents or printed publications in the concurrent district court litigation. On the other end of the spectrum, we have the Sand Revolution style stipulations, and here the petitioner agrees to drop any invalidity ground specifically raised in the IPR petition if the IPR petition is instituted, meaning that if the IPR petition says the claims are invalid because of A over B, that specific ground of A over B will not then be asserted in the district court litigation, but that petitioner could still assert A in view of C in that case. And a little bit in the middle, you have this VMware style stipulation. And so there, the petitioner would agree to not use any of the IPR references in the litigation if the IPR is instituted. So in that kind of example situation, neither reference A or B could be used regardless of how it would be combined with other outside references. And also for petitioners here, obviously, FinTIV is still on the books, and so you have that compelling evidence standard now based on Director Vidal's June 2022 guidance. And so it's important here to really focus on any strong merits or unique facts, really play up the fact that you as a petitioner have met your compelling grounds for unpatentability. And from the patent owner side, obviously the patent owners were happy with FinTIV. It was helpful for them. It prevented a lot of institutions. And so what are some things that patent owners can do in this new era at the patent office to help prevent institution? And so as an initial matter, really, it's best if you can catch the accused infringer off guard here. Any substantial pre-investigation or pre-suit warning can give the petitioner an extra warning on this, that a potential suit is coming, and essentially allow the petitioner to get their ducks in a row, get the IPR petitions almost ready to be filed. And so the less notice that an accused infringer has in this case, the harder it is going to be for that accused infringer to be able to get everything in line and get IPRs on file in a timely manner. And in that same vein, assert as many patents as claims as possible. The more patents and the more claims then turns into the more petitions that petitioner will need to file, and it just increases the amount of time that it will take to get those petitions on file. Finally, as a patent owner, also highlight potential lack of diligence and substantial investment in resources before the district court. FinTIV is still on the books, and so focusing on any of these 6 FinTIV factors is definitely important. Highlight the timing differences between forums. Obviously, under Director Vidal's new guidance, make sure that as the patent owner, you are focusing on the median time to trial within that district, and do not cite to the specific case schedule that is governing the district court proceeding, because that will no longer kind of carries as much weight in front of the patent office. And finally, you are given the benefit as a patent owner of that compelling evidence standard. So highlight the weak merits of that IPR petition, play up the higher burden of proof on the petitioner at this point, and make them really establish that compelling evidence of unpatentability.
All right. Thank you, Alec. So I'll talk about the director review process now. And just quickly, the one thing that I want to note before we get to director review on FinTIV is prior to Director Vidal taking office and our updated guidance, we were having this conversation back in 2020, early 2021, for example. I would have had my own internal kind of green light, yellow light, red light stop signal analysis. And in my mind, it was, you really had to rush to get your IPR on file when FinTIV was still really kicking and in force. And I kind of viewed that as 3 months. If you were on file within 3 to 4 months, you didn't have to really worry about a stipulation. That's your green light. Your yellow light is if you're somewhere between 3 and 6 months, you would have wanted to consider a stipulation. And if you were outside of 6 months, that's your red light. And if you want to get that IPR instituted, you really better file some sort of stipulation. I think that is now kind of gone out the window, as Alec mentioned, although technically still on the books. FinTIV is on life support. It's applied very infrequently. It's something that as a petitioner, you absolutely still need to consider and weigh it in your analysis, but it tends to apply more in outlier cases now. And so if you don't think you have an outlier case, you may not have to worry about FinTIV all that much. So turning to director review here, and all of this stems from the Supreme Court decision in the United States v. Arthrex. There's a very long history here, which some in attendance may be familiar with, but the short of it is that ever since the advent of the IPR process and these effective post-grant proceedings, patent owners have been a bit unhappy, and they didn't like this tool that accused infringers could wield against them to either slow their progress in the district court or invalidate their claims completely. And so various parties from time to time have been trying to say that the IPR process is just unconstitutional and it has to go away. The Arthrex case was one such challenge, and it centered on whether or not the APJs, or the patent office judges who are deciding IPRs, are actually constitutionally appointed. And that went all the way up to the Supreme Court, and the Supreme Court said that these judges actually were not constitutionally appointed because they had unreviewable authority during the inter-party review process, which is incompatible with their appointment by the secretary to an inferior office. So what that means was that because they had so much authority, they technically should have been appointed by the president and not one of the president's appointees. And so the way they were appointed was unconstitutional. The Federal Circuit had its own fix for the problem, which was essentially to take away their kind of statutory employment protections. The Supreme Court disagreed with that and said the way that we can solve this is just to make sure that the director, who is in fact a presidential appointee, may review final PTAB decisions and upon review may issue decisions himself or herself on behalf of the Patent Trial and Appeal Board. Very quickly, I think really within days after this Supreme Court decision came out, we had the interim director review process at the PTAB. And so what is this process? Well, it's essentially an ability to request rehearing and or reconsideration that parties are likely familiar with in a district court or any other type of appellate proceeding, but you're doing it to the director, him or herself. And so some mechanics that you should know about: the director review process at current is limited to review of final decisions, not institution decisions, only the final written decision. That being said, the director, and we'll talk about this more later, has significant power to, on her own accord, review institution decisions, and she can do that through the director review process. So what ultimately happens here is that if you, as a party, if you have a final written decision that you're unsatisfied with, the party can either request director review or panel rehearing. And also what you can do is the panel can request director review of a decision granting panel rehearing, but not denying panel rehearing. So if you have a final written decision and you're either a petitioner or a patent owner and you're unsatisfied with it, you can either, prior to appealing to the Federal Circuit, you can say, do I want to have my panel rehear this, or do I want to go direct to the director? You can go direct to the director, and if you do, that kind of exhausts your internal appellate process at the patent office, or you can request panel rehearing. And if that's actually granted, then the party who's dissatisfied with that could request director review. There's a 30-day time period for this decision or for your petition requesting director review, and there's currently no fee, although that could change in the future. And you're not allowed to present any sort of new evidence or new argument in your request for review, and typically even your case law citation should be grounded in what happened in the proceeding below. And all issues, whether they're fact issues or law issues, are going to be reviewed de novo by the director. And so what are some issues that may actually warrant director review? This is not a I'm dissatisfied, I think the panel got it wrong, therefore I'm going to appeal within the patent office because I think the way the office or the panel read a reference or weighed expert testimony was incorrect. That argument is never going to work for director review. Maybe it'll work on appeal because there are, appellate standards and evidentiary standards that the court will look at to determine whether the panel operated correctly. But that type of argument is not going to work for director review. So what might work? Well, if there's some intervening change in the law or USPTO procedure that the panel misapplied or just didn't apply at all, that may get the director's attention. If there was some sort of material error of fact or law in the PTAB decision, and then this would really have to be a very clearly erroneous, clear-cut error that the panel made, not just quibbling with their ultimate result. If there was something that PTAB misapprehended or overlooked, but again, this has to be a critical piece of evidence or argument not your run-of-the-mill complaint. There's some novel issue of law or policy. If there appears to be some sort of legal issue where the PTAB panels are split, that may be a good issue to bring up to the director via director review. And then there's kind of some broad catch-all here, issues of particular importance to the office or patent community. We could all probably debate and agree or disagree on what that might be, but certainly she has some broad catch-all authority there. If there's inconsistencies with the office's guidance and memorandum, that may be an issue. And she said, other than these 6 or 7 general categories, additional issues are going to come up sparingly, if at all.
Chris, looks like we just have a quick question in here. With the kind of creation of this director review process, where does this leave the precedential opinion panel? Do we have any guidance on kind of what's going to happen to that? How both of these two things kind of will interplay?
Yeah, it's unclear at this point. I know Director Vidal, I think a few times and even very recently, has stated that she is looking very carefully at the precedential opinion panel and really whether after this director review process, if that's still warranted. And so the precedential opinion panel, what we would call the POP, may go away. That'll be subject to notice and rulemaking, I believe, although don't quote me on that. And I think her current thought may be, some sort of panel where you can try to bring up, clear errors, just some mechanism short of director review to get some sort of internal overview on decisions that have clear errors in them, which would be different than the POP. And I think the POP could largely be replaced by this director review process. And so that gets us to some exemplary director review decisions. And quickly before we do that, I just want to give you some very quick statistics here. And there's actually an Excel spreadsheet that the Patent Office updates. I don't know if they update it monthly or every other month, but you can download this Excel spreadsheet and it shows you every single request for director review that has been out there and what the status of that request is, granted, denied, etc. So as of November 15th, there were 226 requests for director review, 15 granted requests, but out of those 15 granted requests, 10 were actually that sua sponte authority where the director herself decided there's some particular issue in this case that warrants a unified voice or decision from the Patent Office. And so when you factor those out for party-initiated requests, there's only about a 2% chance success rate. So that corroborates what we were saying earlier, which is your run-of-the-mill disagreement that you might have with the panel decision isn't going to go nowhere before the director and a request for director review. You're really looking for a unique, particular set of circumstances that is going to warrant a request. And so the first case that I want to talk about, and I'll try to do so quickly because the facts are voluminous here, but this is the Open Sky v. VLSI case. And VLSI is a plaintiff. They had sued Intel in the Western District of Texas. There's been multiple trials that have gone forward between VLSI and Intel, but I believe the first trial actually resulted in a $2.2 billion infringement verdict against Intel. So huge damages verdict, very big case that the IP community was following. Intel had previously filed an IPR request against the VLSI patents, and at least the patent that was at issue in this case, that was denied under FinTIP. So without looking at the merits, it was denied. This entity, Open Sky, which kind of popped up out of nowhere, they later filed a copycat petition of what Intel filed, and they did so to try to leverage some sort of money out of VLSI, in exchange for dropping the IPR. Pay me. The Open Sky IPR was instituted, and Intel actually joined it, as they are allowed to do under the Patent Office's rules, to get their crack at this patent that they otherwise weren't able to have a crack at. And Director Vidal granted sua sponte review to determine whether OpenSky abused the IPR process. So what did she find? Well, that OpenSky did indeed abuse the IPR process by filing an IPR to extract payment from either VLSI or Intel. And, it was prior to institution, they were trying to get money out of VLSI, or at least prior to Intel joining, trying to get money out of VLSI to drop the IPR. Then when that didn't work, they turned around and, tried to get money out of Intel to make sure that OpenSky stayed in the case and judiciously prosecuted the IPR. Otherwise, there's evidence that they just would have let the IPR essentially fail on its own, so Intel wouldn't be able to get the benefit out of it. During Director Vidal's inquiry into all of this, she stated that OpenSky willfully disobeyed her discovery orders. They produced very minimal documents that were requested. They didn't answer her interrogatories, and they didn't produce a privilege log, which all of the other involved parties did. And so, the quote unquote sanction here, at least as it currently exists today, is that OpenSky cannot actively participate in the IPR proceeding. However, Intel, as a joint petitioner, is able to stand in the shoes of OpenSky if that original PTAB panel found that the petition met that compelling evidence standard that Alec talked about earlier. Compelling evidence or compelling merits were actually found. And so Intel is moving forward, but Director Vidal is separately reviewing that decision. And I think, certainly a takeaway on my part about this decision is Director Vidal, how she believes IPRs should flow is that they're here as a tool that Congress created to check the validity or patentability of a patent, and there shouldn't be artificial barriers put up. Fintiv, I think in her mind, may be one of those artificial barriers that she's now taking down. And although she had a very bad actor here, there's clearly a very impactful patent that's at the center of this whole proceeding, and she may allow Intel to continue it forward.
Chris, one additional question here.
Yep.
Note that OpenSky was precluded from participating in the actions. Obviously, Director Vidal criticized OpenSky's actions. Are there any additional sanctions forthcoming?
Yeah, so Director Vidal is currently considering what to do. I think, there's been a big uproar about this, rightfully so. This was a clear abuse of the IPR process, and without some teeth, other parties may attempt to do it again if the only thing that they're punished is, they're being removed from the proceeding. And so I think there is some suspicion, in the post-grant community that, at a minimum, there'll probably be some award of attorney's fees, which certainly would be an extraordinary remedy that you rarely, if ever, see coming out of the PTAB and the USPTO. So the next case that I want to talk about, and I know we're getting close on time here, and I want to get to the guidance memorandum, so I'll go quickly here, but this is this Code 200 the Bright Data case, and I believe all of the attendees will be getting these slides, and the webinar will be up online, so you'll have the text. But the short version of the story on this case is that Code 200 filed IPR petitions. They were denied under Fintiv. Another petitioner later challenged those patents, and Code 200 tried to join the patents, or to join those IPR petitions, and that was denied under a separate discretionary rubric called General Plastics, dealing with whether one party should be able to get two bites at the apple, essentially, and file multiple IPRs against the same patent. That went up to director review, and what Director Vidal had said was, if your first bite at the apple is discretionarily denied. In other words, that first petition that you filed was filed for some reason other than the merits. Maybe it could be fintive, or maybe it could be another reason. And the panel never actually weighed in on the substance of your arguments. They never gave you guidance on your arguments in view of their critiques. Then the underlying rationales of this general plastic rubric don't really apply, and therefore Code 200 should actually be able to join these IPR petitions and participate depending on what happens in the case. And so the merit panel actually later instituted and granted joiner in this case. And so I think this is just another instance where we see Director Vidal is very, very concerned with the practice that FinTIF created, and she showed us that in Open Sky, and the office is showing us that here in Code 200, that we don't want to allow people who are burdened by FinTIF, which I think the office clearly views as an outlier set of circumstances now. If they were unfortunately burdened previously and they have a chance to rectify that, they will allow them to proceed down and exhaust whatever remedies they have within the office to get their IPR instituted. And so then a few other cases here that were director review decisions that were recently instituted. Again, all sua sponte, so these were all issues that the patent office or that Director Vidal thought warranted a saying from her office and from her voice. And the two that I would like to point out are just the first two. So in NXP, what Director Vidal said is, Alec talked earlier about the stipulations to try to avoid application of FinTIF. And if you're going to go ahead and you're going to file a stipulation, what NXP says is that you have to do so prior to the institution decision. You can't get an institution decision that says you're denied because FinTIF and then come right back and go, well, here's a stipulation to rectify it. You have to get out in front of that. And then the Avia Games decision, this is the one Alec mentioned earlier. This is the one case that was discretionarily denied under FinTIF in Q3 of this year. And it was done in view of a 101 finding at the district court that killed the claim. And the panel said that, well, since the claims and the patent are now invalidated under 101, we are going to exercise our discretion to deny your IPR petition. But of course, IPRs cannot be based on 101 invalidity grounds. And so the director is considering whether if there's an invalidity finding for some sort of ground that cannot be part of an IPR, if somehow that can still form the basis of a discretionary IPR denial under FinTIF. So it looks like we have about 7 more minutes, Alec, but I'll let you kind of quickly go through the guidance memorandums, and then we can give some very quick concluding thoughts here.
Yeah, thanks, Chris. Kind of just try to quickly focus through this. First up is Director Vidal in June 2022, similar to when he had issued guidance on the FinTIF. She had also issued some guidance on applicant admitted prior art. And so this guidance remains pretty consistent with the Federal Circuit's decision in Qualcomm, which also came out in 2022, but essentially states that the basis of an IPR challenge is limited to patents and printed publications. That is dictated by statute, but that applicant admitted prior art can be relied on in combination with one or more documents. So the applicant admitted prior art here, we have kind of 2 different examples here, but that the applicant admitted prior art could be either the primary reference or the secondary reference, so long as that is in combination through 103 with a patent or printed publication reference. And so either situation there is okay, but the one instance under 103 where applicant admitted prior art cannot be relied upon for an IPR challenge is a 103 obvious grounds solely in view of just the applicant admitted prior art. You need some touchstone for a patent or printed publication here in order to meet the statutory requirement. And so Director Vidal, in her guidance, kind of offered some suggestions on how applicant admitted prior art could be used under Section 103. And so it could be used to supply missing claim limitations, support a motivation to combine, or just generally to demonstrate the knowledge of a person of ordinary skill in the art. And finally, notably, the guidance suggests that the number of claim elements that the applicant admitted prior art is relied upon to teach should not ultimately influence the decision, as long as essentially one claim element is relied on or taught by the patent or publication. The remaining limitations or claim elements can be found through the applicant admitted prior art. And then second, moving on, is 101. Obviously, subject matter eligibility and Section 101 has been a major focus on the Patent Office since the Supreme Court's decisions in Alice and Mayo. And so dating back to 2010, kind of that 2014 timeframe, we see a significant push from the Patent Office, as well as kind of the federal courts, in order to really clarify subject matter eligibility. So a little bit of kind of a high level on what the Patent Office was doing on subject matter eligibility prior to Director Vidal was issuing guidance in 2019, updating that guidance, a report to Congress noting that that 2019 guidance resulted in a nice decrease in the likelihood of receiving office actions with a 101 rejection, and also generally just decreased uncertainty about 101 determinations, both from an examiner's perspective as well as from an applicant's perspective. The Berkheimer memo was an effort just to kind of update this subject matter eligibility guidance in view of the Federal Circuit's decision in Berkheimer versus HP, as well as the Patent Office also implementing this deferred subject matter eligibility response pilot program. And while this program has ended in the sense that new applications can no longer be invited to join this pilot program, we expect this pilot program to continue on for about another year or two as these applications progress. And it was kind of a two-part goal here, in that the Patent Office with this program seeks to resolve all other grounds of unpatentability, so 102, 103, 112 issues, prior to addressing any potential 101 concerns. And so I think the thought here is that perhaps by addressing these other grounds of unpatentability, that the 101 grounds will somehow resolve themselves through the amendment and the back and forth prosecution process, as well as potentially also just ending an application's life. Some applications will certainly get abandoned prior to both the Patent Office as well as the applicant having to deal with any potentially unclear, uncertain subject matter eligibility restrictions. And so then moving towards Director Vidal's approach to subject matter eligibility since her term, there was the June 2022 report to Congress related to subject matter eligibility. And I think there are two real notable findings here, in that stakeholders agree that 101 needs to be clear, but that different stakeholders in different industries have diverging views on this issue. And in July, Director Vidal announced an effort to tackle subject matter eligibility through the formal notice and comment rulemaking procedures. And I'd opened that up to comments and had received 33 comments by the time that period had expired. And so we're looking forward to seeing kind of what comes from that in the coming months and years. And finally, a major topic within patent law and intellectual property in general is just the emergence of artificial intelligence and emerging technologies. And so in June 2022, Director Vidal, kind of consistent with some of her statements prior to taking office, in which she had noted that she'd like to focus on AI and emerging technologies, announced an AI ET partnership. And this is really just a series of meetings with the Patent Office as well as other interested parties, focusing on incentivizing innovation and investment and figuring out really what the best path forward here is for how the Patent Office should tackle AI and emerging technologies within this process. And also, kind of just a side point, is the Thaler versus Vidal decision from the Federal Circuit, which came out late this summer and essentially just confirmed what the Patent Office had already been interpreting, but that the Patent Act requires that inventors be natural persons. Therefore, artificial intelligence or computers cannot be listed as named inventors on applications.
All right. Yeah, thank you, Alec. This is certainly going to be an area that the law always tends to trail technology, and I think the law surrounding AI and emerging technology is going to be developing for quite some time, and we will certainly be tracking that here at Oblon. So I think with that, we're just about at an hour. I think we have a few more minutes to give everyone some final concluding thoughts. And the first one that comes to my mind is that, as you can see, particularly with fintive and discretionary denials, that director-to-director viewpoints can be and sometimes strongly opposed to one another. And unfortunately, it does tend to make the agency look more political and have less credibility. And I think that is just a construct of the fact that the USPTO is part of the administrative branch in the United States, and so it is always going to sway one way or another depending upon who's at the helm of the USPTO. But I do think that Director Vidal is certainly doing her absolute best to be proactive and to be transparent so that there's never any question about what the office is doing and why she's doing it. As issues come up, whether they're raised through a precedential opinion panel, through requests for director review or otherwise, she's acting quickly, she's monitoring cases, and she's giving guidance where she knows that stakeholders want guidance. And she has blogs that she actively writes on, she actively participates in trade conferences and in the IP press, and I think it's very transparent as to how she believes where the office should be heading. And so I think that is a very good thing, particularly given what we can see that with different administrations, the direction of the office does tend to deviate a little bit. However, with transparency, I think those concerns can be alleviated, at least to a certain degree, obviously depending on what side of the question you fall on. And she's obviously taking very significant interest and ownership over the director review process, providing very detailed guidance on how to go about the process, what issues may warrant attention, and also just detailed web pages tracking for stakeholders the decisions that have been granted, the ones that haven't. And again, just an effort of transparency to make sure that everyone knows, what her office is up to, and that there's no questions and no surprises out there. And I think, as we had mentioned earlier, Director Vidal is trying to push towards more formal rulemaking, which certainly has been a knock of some directors in the past, that they essentially did policymaking through the decisions that the director had made. And so I think Director Vidal has stated that policy should be left up to Congress and the political process, and that's not the role of her office. Or if there is going to be policy that's going to be implemented, it will be done through formal notice and rulemaking. Otherwise, she's there to clarify what the state of the law is, to provide certainty for parties. And I guess, Alec, I ask you, and I know we only have about another minute or so, but do we think it's even possible for directors to go through the long, laborious process of notice and formal rulemaking?
Well, yeah, I mean, I think it's an interesting point. I mean, I think even going back to the previous administration, I think they would have liked the opportunity to. I think the formal rulemaking procedure takes time. And so I think it depends on how long we're going to see Director Vidal in office, whether or not she's able to kind of make some more permanent changes through the rulemaking procedure, or whether or not she's going to be left up to just kind of these guidance memorandums, and which obviously can just change drastically administration to administration. But I mean, we're seeing that with subject matter eligibility. She's pushing forward the notice and comment rulemaking, and I think this is something that, regardless of administration, all stakeholders agree that something needs to be done here. So whether or not that this gets finalized within Director Vidal's time, I could certainly see a subsequent director continuing carrying the torch here. And just as like on a final note, Director Vidal has also kind of made a big push to expand diversity and inclusion within the patent office and within the patent and IP space in general. And obviously that's not something that you always kind of you would expect from a US agency like the patent office, but certainly much welcomed and perhaps long overdue here.
All right. Well, thank you, Alec. And I think with that, we're at the end of today's webinar and topic. We appreciate everyone's time and attendance. We really thank you for that. We wish you all a happy holiday season and a very safe and prosperous 2023. And if you have any questions about the slides today, about the content or the webinar, please feel free to reach out to either myself or Alec, and we'd love to connect with you. But thank you very much.
Thank you, everyone.